So you've interrupted my proceedings at this stage. So I'm wondering if I should hold you in contempt right now. No, you need to pick up your paper. If you leave, I will have your ass arrested.
If you are called to testify as a witness in this matter, is it your assertion that you would be asserting a Fifth Amendment privilege?
Yes, based upon all the things that I've heard from both of these people.
Sit down. You're coming up in here in the middle of my proceedings and interrupting my proceedings. Who do you think you are? I did not address you. I don't know who you are. That's not proper service. That's not proper service. And by the way, that's not proper service. You're coming up in my courtroom interrupting me.
Marquise Ivy was both GSTI's in-house counsel and also Mr. Kennedy's personal counsel. We have specifically a recording of a board meeting, Your Honor, where Mr. Ivy is present. And I don't know how much detail, given the defense has the right to preserve some of its trial strategy. I don't know how much detail is necessary, Your Honor, but I can say with 100% confidence that this board meeting would show, one, that Mr. Ivy was Mr. Kennedy's counsel, two, that Mr. Kennedy sought his advice as to the specific threshold issues that are raised in this case, that at this meeting, Mr. Kennedy explains to the group and Mr. Ivy nods in agreement that they've conferred that he has obtained advice from Mr. Ivy that would suggest that his conduct is fully legal. He makes specific reference to his criminal history from 20 years prior. He also makes specific reference to his name, which are, again, the two threshold issues in this case. And most importantly, the board then proceeds to take a vote acting upon Mr. Ivy's advice to Mr. Kennedy, which Mr. Kennedy, again, relies on at all times.
As of now, a subpoena was attempted to be served by the people on Mr. Ivy. And my understanding is that attempted subpoena service was July 1st of 2026. Is that correct?
Yes, Your Honor. I believe that Investigator Gaffney served Judge Ivy on July 1st.
The non-disputed statements are that on July 1st of 2026, Mr. Ivy was serving in his capacity as a county court judge in Adams County. He was in court on that day, present in courtroom, and was on the bench. During that time period, Investigator Gaffney entered the courtroom in the morning hours. At some time during that morning period, he attempted to serve Judge Ivy with a subpoena while he was seated on the bench. From all accounts, Judge Ivy indicated that service was not proper in the courtroom. And at some point, service papers were left on the floor. Whether they remained there or not is up to dispute. But at no point were the papers actually given to Judge Ivy, and the investigator did not make his way to the actual bench. The court would note that it has not seen service of this nature in its time as a practicing attorney or as a member of the court. I would also note many courts have policies against service being performed in a courtroom, including this court, which does not allow service to be performed in the courtroom due to the disruption of judicial proceedings and the disruption to judicial decorum. My understanding, though, is on the date in question, Judge Ivy indicated that that would not be proper service and, in fact, threatened to find the individual in contempt of court.
Specifically, it's our burden to prove that he's guilty beyond a reasonable doubt of 7 counts of securities fraud, which were mentioned to you previously. You'll hear evidence that when dealing in securities, the seller is required to make, quote unquote, material disclosures. In this case, you will hear that Mr. Kennedy failed to disclose information prior to accepting investments in his companies. You will hear that Mr. Kennedy didn't disclose to the investors that he used aliases and that he didn't disclose his legal name. You will also hear that Mr. Kennedy didn't disclose that he had prior criminal convictions and prior negative civil judgments against him. Because he did not disclose these facts, the investors were not able to consider these facts before investing and reinvesting in his companies.
Mr. Lockwood, if you truly believed Dempsey Kennedy was running an illegal, unethical scam, why would you offer to continue working for even a moment more?
Because I didn't want to believe it. I liked the defendant. I had no issue with him prior to that going on. I just felt it was either so amateur that it bordered on illegal or was something that I couldn't ethically support. I couldn't prove that there was intentional illegality at that point, but I knew that what was happening was illegal and unethical and that I could not continue to do that under those conditions.
Did Mr. Ivy have an interest or any kind of financial involvement with this company?
And the question was if Mr. Ivy was involved in the company.
Yes.
So there are multiple companies, one being Blackwall Canna that is involved, and Mr. Ivy is listed as the president of that company.
One of the also prohibitions on an advice of counsel defense is that if counsel has an interest in the activity that's ongoing, then that cannot establish a good faith defense because the advice of counsel has to be from a counsel who is disinterested and independent of the activity. And so that's one of the reasons I am inquiring into this area.
Whether or not to change my shoes. It seems really odd to be here as opposed to being someplace else, but this is the first time that we've ever done it. So you're here now, and you are a part of the GSTI 2020 fourth quarter presentation, and I am the chairman and CEO, August Alexander, and I thank you all for again joining us.
Open space is bringing us back together. Stronger, safer, smarter.
Our next groundbreaking business expansion for Gavin Smarter Technologies in 2020 is GSTI Biodefense.
The Drive app being released by OpenSpace Auto is enabled by the technology of the AutoTrack 1000 identification card. It is a patented technology that creates a digital home for your vehicle's information, auto insurance, and your personal driving credentials.
Now, my name is August Alexander. I'm the host of the Real Estate Report, and I know, seems like I got everything. Magnificent views. I just murdered some kid on online Nintendo. Yeah, online Nintendo. It's from the future. I mean, it's hard being me sometimes, but I've got a great crew, guys, that help me look super awesome every week when I do my show.
During your investigation, did you determine that these people knew Mr. Kennedy as Dempsey Kennedy?
I don't believe I've interviewed anyone that knew him as Dempsey Kennedy.
Did you ever discover how exactly the name August came to be used by Mr. Kennedy?
How we picked the name August? I don't know if I know the origin of that.
It's not his middle name, is it?
No, that's Alexander.
So was this name used as a nickname?
It doesn't appear to be. At the end, there's credits where he's listed as August Alexander. Oftentimes with nicknames, you'll throw quotes around them, maybe put your real name, bookend it, something of that sort. But it appeared to be August Alexander, both verbally and through the credits.
What are the first steps you take when looking into financial records in investigations generally?
The order of operations I'll use is if I have identified investors who invested via kind of a traceable transaction, a wire, a cash check, something, some sort of bank transfer. Normally, if they're able to get me those documents, I can then find out where their investments were deposited or at least transferred into. And that's usually my starting point will be the bank of first deposit. If the money transfers to other accounts or gets withdrawn through cash or other ways that it'll come out of an account, I have to account for that and follow them to.
Are these processes You described generally accepted principles of fraud examination.
They are, and I don't want to call it a technique. It's called LIBOR. L-I-B as in boy, R stands for lowest intermediate balance rule. That's been essentially the best practice in federal money tracing or asset tracing in commingled accounts. So that is the process that we use instead of, there's other accounting, first in, first out, or last in, first out. But LIBOR gives the most credit to the account holder for funds that are in the account that are commingled with investor funds.
Pursuant to the court's order, I did email Judge Ivey and let him know the court's ruling that the court did authorize the subpoena insofar as WebEx testimony, but he was not required to come and testify in person. Initially, I got an automatic response that indicated that he was on travels and had limited access to internet or phone because he was near mountains and volcanoes. He responded and said that he respects Judge Angel's decision as it relates to his courtroom, but clearly I will be addressing those specific issues in my courtroom upon my return. Based upon advice of counsel and further discussions with others, I will be pleading the fifth. As it relates to us being in an AI-centric society with the ability to manipulate video, audio, and pictures, and me not putting it past Mr. Lyons based upon discussions with others, I will not leave myself exposed to made-up claims.
Mr. Ivey has indicated at various points in time that he will be on an airplane on July 7th. In his motion, he indicates he is on an airplane currently on July 10th. He indicates he's on an airplane on July 13th. And then we have the indication that he's going to be on an airplane on July 20th.
I think what the people would kind of be forced into a position where he makes himself unavailable pursuant to the subpoena, the people would have to request a continuance given his unavailability. People would request the court hold him in contempt, but would obviously defer to the court in terms of staying any enforcement of that until Judge Ivey is back.
The court would note that it does have some individuals on the WebEx platform, including Judge Ivey, who was endorsed by the people as a witness in this case. The people advised the court that, as it related at least to Judge Ivey's testimony and their communications with Judge Ivey, that it was relayed to him that Judge Ivey indicated he would assert a Fifth Amendment privilege as to any testimony. So Judge Ivey, as you have heard from the court, Mr. Kennedy, as part of his endorsement of defenses, has endorsed advice of counsel. Based upon that assertion of a defense, the people have indicated that they wish to call you as a witness in their case in chief to negate that defense. At this time, I want to ask you, if you are called to testify as a witness in this matter, is it your assertion that you would be asserting a Fifth Amendment privilege?
Yes, based upon all the things that I've heard from both of these people, yes.
He was very forthcoming at the beginning, back in January when we originally interviewed him. He was told that he was a necessary witness when the continuance was granted at the last court date. Mr. Brasher reached out to him the week of June 22nd, which was 2 weeks before the first before the first day of trial, and received no response. Mr. Gaffney, Investigator Gaffney, then reached out to Judge Ivey over the phone and received a call back, at which point Judge Ivey indicated that he would refuse to appear. At that point, that's when the service occurred of the subpoena, which the court did find that Judge Ivey was a necessary witness and did not quash the subpoena. At that point in time, Judge Ivey asserted a Fifth Amendment privilege. And at no time prior to that point did he assert a Fifth Amendment privilege until the court confirmed the subpoena.
Have you been able to consult with counsel as to your assertion of the Fifth Amendment privilege and any legal liability that would be exposed?
Yes.
And you're obviously a licensed and practicing attorney yourself, is that correct?
That is correct.
Then my understanding is based upon that advice, as well as your own independent knowledge, you believe that you have a Fifth Amendment privilege as it relates to any questions that may relate to an advice of counsel defense?
Yes, primarily because it seems like Mr. Camera or something made some statements that there's some alleged video out there, which I know to be patently false. But nonetheless, based upon that statement that he made, that apparently there was some advice given to a board of directors. That was what he had wrote, a board of directors. So not to this defendant, but apparently to a board of directors, that I apparently told these people that this defendant can use fake names and take people's money, I guess. There's some recording, he said. According to counsel, they said, claim the Fifth.
Judge Ivey, the video you referenced, have you had an opportunity to review or view that video?
I've seen no video. According to the prosecution, there allegedly are some text messages which they refuse to share as well. So I've seen nothing.
I'll just also note that it appears that Judge Ivey is denying any evidence that would implicate any self-incrimination. To the court, he just indicated that Mr. Camera provided false statements and that he did not provide advice. And so I think statements provided to the court directly undercut any type of privilege asserted at this point.
Mr. Camera?
Defense agrees. And it's remarkable how many times this morning I found myself agreeing with the people. That's very unusual. But to the court's inquiry whether or not I could make the video of Judge Ivey sitting on the board of GSTI dated January 28th, 2020 available, I just emailed it to Judge Ivey for his review.
All right, thank you. Then I appreciate you making yourself available while you're on vacation. I hope you have a good rest of your trip, and thank you for your time this morning.
Thank you very much, Judge Angel. Have a good day.
You too.